All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here for oral argument in our case number CV22-0565, Smith v. Olsen. I would remind you that we're recording and live streaming the arguments, so please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. And appellant's counsel, if you watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, and have discussed the case in conference. With that, counsel for appellant, you may proceed.
Good morning, Your Honors. Ryan Lorenz from the firm of Clark Hill on behalf of the appellant. Sitting at counsel table with me today is my colleague, Barrett Lindsay. Your Honors, this case is before you because of a runaway trial. And the trial became so because of a pretrial order made over 3 years before the trial started. This order was unjustifiably kept in place by a different judge than the judge that made the original order.
Excuse me, counsel. Rule 16 can be very draconian. We understand that. I was puzzled in reviewing this as to why after March 2019, when Judge Ostrowski later on during the pandemic was generating these orders to file pretrial statements, why Mr. Olsen's counsel didn't file for him an amended one or say, you know, we didn't file one in 2019, but we'd like leave to file ours now. Why did that not happen?
That's actually the focus of most of my planned comments were today. I would divide the answer to that question into 3 separate time frames, and if I start to wander off, it's because there's a long period of time with which to deal with where there was that opportunity. We can see there was that opportunity to do that, but it didn't happen. And I say that in the passive voice as if it's nobody's fault, but it is somebody's fault. And allocation of blame on that question is pivotal in determining whether the judge abused his discretion. So the first time frame we look at is from March 15th, 2019 to September 1st, 2021. During that time, after Judge Campagnolo issued his order, there were 4 separate trial setting orders, all 4 of which contained the same language that said the parties shall file with the court no later than 10 days before the final trial management conference a joint pretrial statement signed by all counsel. So whatever sins had been committed by the defendant prior to the March 2019 order seemed to have been washed free by those 4 orders.
Whether they were or not, he was then commanded to file an amended one.
Correct. Now, in reaction to all 4 of those orders, neither side did anything. Nothing was filed with the court, and particularly timing here matters. These orders were issued January 2020, March 2020, December 2020, and June 2021. If what ultimately later happened had happened with respect to those orders, the court would have seen, and this record would have reflected, an amended pretrial statement or some pretrial statement filed by the parties on those dates for the final pretrial conference minus 5 months, which is what happened subsequent to the September 1st, 2001 trial setting order. So during that time frame, both sides, I believe, are to blame for not following up. When Judge Ostrowski...
But Ms. Smith had already filed one. I mean, she had less incentive to file another one because she didn't need to amend having filed one. But Mr. Olsen was kind of hanging out there in the wind, and his counsel seems to have let him down more in that regard.
Well, I agree that his counsel did let him down, and this court may be aware or should take judicial notice that Waleed Zarifi was suspended from the practice for 6 months and a day as a result of complaints by the defendant and other clients of his. But nonetheless, when we look at the second period of time, which is September 1st, 2021 through October 12, 2021, Judge Ostrowski takes the file, sets a new trial for 2022, and says both counsel shall contact and communicate with opposing counsel regarding the final pretrial statement previously filed and submit an amended final joint pretrial statement that identifies any agreements reached and any remaining issues not previously identified. In reaction to that, the draft was, a draft amended joint pretrial statement was provided by plaintiff's counsel to Mr. Zarifi on 2 occasions. There's nothing in this record about a phone call, an attempt to schedule a meeting, or do anything else which our courts, superior courts, expect of counsel preparing a case for trial.
I apologize for interrupting, but we're already 4 minutes from the time of my question. So basically, it's Zarifi's fault is what I'm hearing. Zarifi let Mr. Olsen down is why there was no attempt to file a reciprocal half of a pretrial order.
If blame is to be cast, I think you'd have to divide it. It seems like it's a close call between whether it's 70-30, 80-20, 50-50. It really doesn't matter because our superior court judges don't sit around and wait for the lawyers to figure out, well, it's his fault or it's her fault as to why something didn't get filed. They just want the work done and the case prepared to be tried. And that's a frustrating thing for a superior court judge when the lawyers don't talk. And if they don't pick up the phone or they don't have meetings, this is what happens. We submit that the amended joint pretrial statement was rushed to filing 5 months before the deadline without any true meet and confer as...
Spotting you that that's entirely correct. It doesn't explain why there wasn't something done after that to say, well, that was filed rashly and early. There's still several months left of the deadline. I'd like to file my half now. It's the same question.
And that's the third, exactly, that's the third time period that I think we need to deal with, which is from October 12, 2021 until April 1st, 2022, when we're inching towards the final trial preparations. By that time, the defendant and his counsel understood the situation to be what Judge Ostrowski later referred to during trial as law of the case. In other words, they understood that there was no going back. There was no relief to be had from that order.
Counsel, let me ask you, there's law of the case that's binding jurisprudentially, and there's law of the case that's sort of weak law of the case, ranging anywhere from, a judge reconsidering his or her own ruling. That's sort of the weakest. Here we have a rotation, but no intervening appeal, no mandate issued, no law of the mandate. If there was doubt about whether things were still in play, the good cause exception that Judge Capignola put in place years earlier was still there.
That's correct. And from our review of the record, we don't believe that Judge Ostrowski recognized...
No, I'm talking about really what your client didn't do, not about what Judge Ostrowski might or might not have thought. Well, there was no showing a good cause. He had failed to engage, failed to participate, and failed to appear. And so, as I read it at least, Judge Capignola said that's unacceptable. Under Rule 16 and Rule 37, the objections to the exhibits are gone, they're waived, deemed waived as a sanction, and you cannot offer evidentiary exhibits. Those are kind of the two things that I think. Not with respect to testimony, not with respect to objections to testimony, arguments, jury instructions, anything like that. There was no effort ever by your client that I see in the record, and if I'm wrong, please correct me, to revisit that.
There is an attempt by Mr. Olsen, when unrepresented by counsel, to provide the court a separate set of findings of fact and conclusions of law, and I apologize, I don't have the record site.
And that may be, that's different though than exhibits and sanctions, right? And I get that you were not trial counsel in all of this, and that Mr. Olsen, for a period of time, had counsel and then didn't, and then did, and then, which creates its own set of challenges. But revisiting that sanctions order was never requested.
And I think the door was slammed shut much earlier than when Judge Ostrowski took the file and made his orders in April 2022.
And I guess my question, and I understand your position, I want to hear from you on damages too, but it's not clear to me that there was any door that was slammed shut because the good cause out was still there but was never invoked by your client.
And the point in time when we think the door was slammed shut and created this understanding by Mr. Zarifi, the defendant, or both of them combined, happened at a status conference on April 21st, 2021, when Mr. Zarifi expressed his understanding, saying Mr. Olsen missed a pretrial conference of some sort of hearing. He mentioned cumulative missed hearings, and Judge Campagnolo was still assigned and seemed to echo that, yes, the order was final. And we think that's why Judge Ostrowski didn't go back to the minute entry, which very clearly said, absent a showing of good cause from the defendant. And
let me ask you one more question, then I would encourage you to address the damages question. But I get your point that the judge could have reopened that. What I'm asking you, though, is different, whether your client asked him to do that. And I just don't see that in the record.
The closest that the defendant came was the submission of the requested findings of fact and conclusions of law that were actually directed to the question of preliminary injunction. But there were serial exhibits, lots of paper attached to that filing, which functionally appeared to be the defendant's entire defense case, and it was completely excluded. I think, consistent with what Judge Ostrowski told Mr. Olsen and his counsel at trial, partway through, was that I don't want to hear any more objections from the defendant. I've already ruled on that. That is over. You cannot make objections to testimony or evidence. I don't necessarily like that, but that's the way this case is going to have to be tried.
And where specifically did Judge Ostrowski say the defendant could not object to testimony? Not exhibits, but testimony.
That was day 6, transcript page 99. Any further objections to their evidence is going to be in violation of that court order. I don't want to have this discussion again.
Well, but to their evidence, but before and after that point in the trial, Judge Ostrowski did sustain objections to the testimony of particular witnesses, did he not?
I think he did at various times, yes, when his instincts as a trial judge took over and he said, wait a second, that's not admissible, or perhaps to speed things along when the testimony was wandering into irrelevant matters.
So again, your phrasing that you read was, it was evidence. It was objections to evidence, as in documentary evidence, but narrative testimony was not subject to the prescription.
I assume when he says evidence, he includes both testimony and exhibits.
But again, as you recognize, before and after that time in the trial, Judge Ostrowski did sustain objections to narrative testimony that were raised by your client's counsel.
And some of those may have been at the urging of defense counsel or may have been sua sponte just to manage the time.
What was done in this record in relation to the trial to work with the statute of limitations argument? You know, the closing argument says, you know, I want 20 years, and says there was $30,000 a year of lost income by Ms. Smith. And there is a post-trial motion that really makes this point. You know, hey, we pleaded this originally, and your post-trial motion, I think, for the remediator says, you know, statute of limitations. What was done in terms of motions in limine or at any time during the trial to try to implement a statute of limitations objection or argument to the proofs that Ms. Smith was making?
During trial, nothing.
Okay.
I mean, virtually nothing, other than objections that didn't have any narrative descriptions or sidebar discussions about the basis.
Did counsel argue statute of limitations to the jury?
I don't believe in closing argument that was mentioned.
Okay. Because I didn't see it. I just want to make sure there was nothing in here that I missed on that front.
No.
And how
However,
about, were jury instructions submitted to talk about the window for damages by your client? I don't recall them.
No, they were not. And the guardrails that should have been in place, either because the judge recognized we can't go back to the beginning of time, and we also, under Rule 15D, should have a supplemental pleading if we're going to talk about facts that aren't pled but have arisen since the filing of the complaint.
Counsel, though, statute of limitations is an affirmative defense that your client pled, but you also then have the burden to prove it. And I'm not getting that from the trial record.
Well, in the joint pretrial statement, it basically steered this trial towards a singular outcome, a verdict in favor of the plaintiff.
But I read, just to, and I'm sorry to interrupt, but time goes fast. And to put a little more nuance on it, I see your brief as arguing that damages were awarded for bad acts over a 20-year or so window, but that the limitations period for the longest count, the breach of easement count, was 6 years, and damages should have been limited to that window. There's a way to do that through special interrogatories to the jury, through jury instructions, through objections at argument and closing, through closing arguments, through instructions that the court otherwise might give. I don't see any of those in this record.
And there's a huge blank spot in both the original pretrial statement from 2019 and the amended pretrial statement from October 2021 on counterclaims. And we think, I actually surprised them standing here because there's no signed order disposing of the counterclaims.
Counsel, I think that's a different issue than what I was asking about.
Well, I guess in the panoply of pretrial filings, no, there were no special interrogatories or separate jury instructions requested by the defendant in advancing those defenses, but much like the counterclaims omission from the pretrial statement, so were the affirmative defenses.
Well, and you pointed out that Judge Campagnolo's order actually carved out, I think, parts A, B, and C of one of the subparts of Rule 16. So actually, kind of ironically, Judge Campagnolo exempted from his later sanction this very thing. So the sanction didn't extend to excluding this from the pretrial order because the ordinary requirement in Rule 16 to provide stipulations of law as to what is a relevant issue, as you point out in your brief correctly, that wasn't there. So this is something that could have been raised in the pretrial practice without violating the sanction.
If I was taking the lead and drafting it, I would certainly include the defenses that were still alive and counterclaims that were still alive just in the process of drafting because I know the other side would put them in there.
Or it could have been invoked by motion because, again, the sanction under Rule 16 did not foreclose that option, right?
That's correct. And I mean, we just have zero content here. There just needed to be more meat on the bones of the joint pretrial.
Counsel, what is your precise argument regarding punitive damages?
So I want to just zoom out to 30,000 feet about the entirety of the trial evidence, and I think that's the view that in the totality of the circumstances and trial evidence, you just have two neighbors who don't like each other. Those are the facts. Nobody would dispute that these neighbors just don't like each other. Now, Mr. Olsen engaged in some sophomoric behavior, some juvenile behavior. I think the record shows that the plaintiff gave some of that back, and it was even happening in the courtroom when the defendant moved for a mistrial. So there's a lot going on here that these two people just don't like each other. That's not the foundation for punitive damages. There needs to be an evil hand guided by an evil mind. And the Linthicum case and its progeny all steer us in the direction of being very conservative on when punitive damages can and should be awarded, or even whether a jury is instructed on them. Now,
Were they excessive if awarded?
across the board, yes. All of these damages don't bear any relationship, particularly the emotional distress damages where the strength here is the plaintiff discussing her own damages and making a self-diagnosis, no medical records, no psych records, nothing that we would expect to see in a true emotional damage case.
That goes to the compensatories. I'm still on Judge Brown's question about the punitives. Were the punitives excessive if we decide that punitives could be awarded? Were they excessive?
I think the Hudgens,
Where do you say that in your briefs?
the Southwest Airlines case reduced an 8-to-1 ratio down to 1-to-1. That's not unusual. Anything outside the boundaries of 1-to-1 has to be pretty egregious. The facts just don't justify that here, even giving the plaintiff the benefit of the doubt. And I'd like to reserve the remainder of my time for rebuttal.
Thank you. Counsel?
Thank you, Your Honor. Just to go through some of the stuff that the court's talked about, there's nothing that Mr. Olsen did or his counsel did to try and undo the sanction order. There wasn't even a conversation with me as a trial attorney by Mr. Zarifi or Mr. Olsen to say, hey, let's do something with the exhibits. Let's do some kind of pretrial agreement. Nothing at all. And I think I put that in the brief. Mr. Olsen was pro se during all those proceedings. Then his attorney stepped in May of 2020. He was around for the next 2 years, all the way until, May of 2019. He was around all the way until May of 2020, and then 4 days before trial commenced, 4 calendar days, Mr. Zarifi withdraws from the case, leaving Mr. Olsen pro se.
Did anyone seek a continuance when that happened?
I'm sorry, Your Honor.
Did anyone seek a continuance when that happened?
No one made any kind of continuance motion at that point, I don't think. I don't recall that. At that point, we had been continued for trial, I think, 7 or 8 times, and it was apparent from the record that Mr. Olsen was, to my mind, exercising continuances or trying to get him in bad faith. He had the 2 bad faith bankruptcies that the bankruptcy court threw out immediately after filing and barred him from filing without going through that same judge again. We had COVID in the middle of that. We had all kinds of continuances, and I think the court was anxious to have this case tried. So
I'm interested to learn where the $600,000 came from in this record. What tether in the record is there to this $600,000 award? The only thing I could see was the closing argument, 20 years and $30,000 a year. What justifies the $600,000 breach of easement damage award specifically?
Well, Your Honor, I think it goes to all the different breaches of the easement that went in, that we showed in the evidence. There were all kinds of assaults on Mrs. Smith.
But you have a count for assault. So you just said because assaults. Okay, so you have a claim for assault and you got money for that.
Right.
So what's the easement as opposed to the assault, please?
There's other things like she couldn't get delivery of essential things like water and propane. Mm-hmm. She had to go to friends' houses or other people's houses to bathe, for example, or do her laundry. Common, things that you and I would take for granted. She had Mr. Olsen attacking anybody that came out to visit her. She had Mr. Olsen slashing tires. There's a whole long litany. I went through that in the brief. He completely blocked the easement. He put this obstruction that went all the way across the easement. It was fully across the easement in 2015. He refused to remove it. He had a court order to remove it. He didn't do that. We had to do it.
How much did it cost to do that?
I think it was $1,500 to do that.
Okay.
But I think the non-monetizable, you can't say it's going to cost me $10 to get blocked from going to my house, or $10 because my friend couldn't come see me. But those are all breaches of the easement agreement, and I would say most of the things that I've listed in my statement of facts, most of those are breaches of the easement agreement. And
we don't in Arizona recognize emotional damages in the context of a breach of a contract, right?
I agree, Your Honor, yes.
Okay, and easement is a breach of contract claim. It's not really about whether you're being terrorized. We have claims for being terrorized in this case. I get that. But
right.
This isn't that, right?
It isn't, but stopping someone to come see you,
sure.
You have an easement right to let your friends come and see you, let your family come and see you. I mean, I don't know what the value of that is, but the jury obviously had put a value on it.
Well, someone does. That's my point. So how, if the jury said $5 million, would that be defensible? If it was $50 million, where's the line? I mean, where is it tied into the record, and what's defensible here?
I don't know.
$600,000 is a lot of money.
It is, Your Honor, but there's a lot of history here. It was clear that Mr. Olsen was doing this intentionally, and I know that doesn't go to the breach of contract claim.
It doesn't.
But he was doing this stuff every time somebody was using that easement, that mile-long stretch. He had the gate locked. He wouldn't let Melissa go in and out to the gate with ease. Did
you provide evidence to the jury that monetized the value of the easement by day, by year, by month? Was there anything to say? In the closing argument, there was $30,000 of lost income. I saw that, and I said, oh, well, that's something.
Yeah.
I can see that. You have 6 years of that under the statute. That's $180,000, but I couldn't find my way to the other $420,000.
And I don't think you can find a calculation that does that, a mathematical calculation, Your Honor. I think it's a jury figuring out what they think is worth to when people are getting blocked to go see her, when the gate is locked and she comes home at 10 o'clock at night or 8 o'clock at night and it's dark and she has to do things to get around that gate to get to her house. Other people can't visit her. Her daughter can't come out and bring her grandchildren to come see her. All those things that Mr. Olsen did, he kept on putting things back into the easement to block her way. He forced her to go off of the easement to go on this unstable slope to get to her house. I mean, those are all violations of the easement agreement. So
it was non-economic damages for the use of the house is basically what it was, and the jury is free to sort of fashion a number in the absence of any quantification by the plaintiff of the rough value of the loss of use of the house and being put to using other paths. So that's what they got there.
Loss of use of the easement.
Well, right.
That was her means of access. That was for
The house, to her house, yeah. It takes her house away when that happens, basically.
Okay. And there's no way of figuring out a mathematical number for that. But I think the jury, they were charged with monetizing that, giving a number.
Counsel,
and fairly think it's appropriate.
let me ask, I've struggled, and you mentioned the intentional acts by Mr. Olsen. I'm not quite sure how, and I'm not sure how, the intentional infliction of emotional distress and the negligent infliction of emotional distress awards can peacefully coexist. They were pled as negligence as an alternative count, if I read your complaint right.
Right.
The verdict is exactly the same. It strikes me that that's an election of remedies, and I'm trying to figure out how this record would support both of those verdicts as opposed to one of those verdicts.
Well, I think probably the biggest factor for me is that Mr. Olsen kept on saying, I didn't intend to do this stuff, maybe I...
And I get that, why it was tried that way, but what evidentiary foundation is different for the negligent infliction versus the intentional infliction? I just don't see it. It seems like it's the same operative body of facts, and especially for a count that's pled in the alternative, I don't see how both those can stand.
I think the operative facts are exactly the same for both. But again, I think that Mr. Olsen kept on saying that, I didn't mean to do this. I think the jury's entitled to say that was a negligent kind of your part.
And I'm not, my question is really more post-trial, after the verdicts come, was it proper to submit both these theories and claims to the jury? I think so. I just don't see how they both stand in terms of a judgment.
Well, they do have slightly different elements.
No question, but again, if they're from the same operative facts, isn't that sort of recovering twice for the same thing on not identical, but really similar theories?
I think they're similar in some ways, Your Honor, but again, I think there's a difference, at least there was to the jury, between negligence and intentional conduct. And, there were no jury instructions submitted by Mr. Olsen or his counsel at the time saying we need to separate these or you need to choose one versus the other one. There was no election of remedy argument even made.
There was, though, in the post-trial motions, for sure.
In the post-trial motions, but that's too late. The jury's already decided the case.
Is it? In other words, if the judge said, well, you can proceed with intentional but not negligent, wouldn't we be hearing a different argument that the jury should have considered both, and the way to sort that out was post-trial?
I think if the judge considered that post-trial, yeah, I think that's potentially the case, but it was not mentioned during trial, and the way to do it, I guess, is to be colloquial, is to provide the instructions to the jury in advance and say, here's the two causes, you need to separate them out in some way or whatever, and the defense put in no instructions whatsoever in that regard. So.
But you said that, to quote, the operative facts are exactly the same for both, which I think is right, by the way. I think you're right to concede that. But where the jury goes on and awards punitive damages on the IIED, the jury has necessarily found under the instructions that your side propounded that there was an evil mind, right?
For the acts that they included in that count, yes.
Yeah, and we settled a minute ago that the operative facts are exactly the same. So with respect to the operative core facts that are exactly the same, he had an evil mind. How can he have an evil mind and simultaneously be negligent with the identical set of facts?
Well, because there were so many incidents that occurred, and I think the jury thought some were negligent and some were intentional. So they took the intentional facts, intentional conduct that they found and said, okay, this is what we're going to award punitives on. And the negative stuff, the negligent stuff, they couldn't award punitives, so they, to my mind, they separated that out. maybe defense should have polled the jury or submitted jury instructions. None of that occurred. So I think that's what we're stuck with at this point, unfortunately.
So let me ask that you address the punitive damage aspect, both, the eligibility of the three claims where punitives were awarded under common law for a punitive damage award, but then also the constitutionality, the due process notice that has become, in the last generation, a lot more significant.
Yes.
Particularly cases saying, hey, to go north of 1-to-1 is a pretty exceptional case, and we're way north of 1-to-1 ratio, and that's a simplistic tool, I concede. But I'd like to hear your position more on that.
Well, I referred the court to the Tartar decision, an unpublished decision. I think that that's some of the arguments I would make. One is we have a case that's different than just a purely economic case. There's harm to an individual. There's physical injury. It's a much more egregious case. If you go through, and I forget the name of the case, but it's a case that says here's the factors you look at for reprehensibility. To my mind, we meet all of those. We've got really severe assaults. We've got all kinds of injury from that. We've got financial disadvantage. So we meet all those goals. As far as the ratio, the constitutionality of the ratio.
And again, I know there's more to the constitutional inquiry than that, but that's the easiest for me to sort of get my arms around.
We probably could go on all day with talking about that. But if you calculate, some of the cases I've seen say you calculate the total compensatory versus the total punitive. And if you do that in this case, it's almost a 1-to-1 ratio.
Which I think is probably not the way to do it here, given that you have a contract case or claim that would not be eligible and a negligence claim.
And I only mention that because the way I think I put it in the brief is that I've looked at the cases of the claims where you get punitives and then did a ratio, and overall we're at 2.86. And it seems like the cases either call that 2-to-1, they may call it 3-to-1, but we're still under that 4-to-1 ratio, where that the U.S. Supreme Court says that's the line that you can't go beyond.
But they've said many things over time, Hislop and TXO and Campbell and BMW sort of started with the 3-to-1, but it seems like that window's closed a little bit in recent years.
I think, again, it's the nature of this case, Your Honor. It's not just someone who suffered economic damage. It's someone who has been assaulted over and over again, who's been deprived of basic life, amenities. You can't take a shower at her house, can't do laundry, is chased up and down this mile-long road, is, threatened, her life is threatened by this guy trying to run her off the road over and over again. She can't get basic services, she can't get propane, she can't see her family, she can't celebrate, holidays with her family, et cetera, et cetera. And to me, it's really outrageous, Your Honor. I mean, it went on, and I think the other act evidence really supports how intentional all this conduct was, and to my mind, a reign of terror over all these years. So.
I think if you had an affirmance of a 1-to-1 punitive damage award, that would respect that conduct was really outrageous, I think, if that were the result. But you asserted at the start of your answer to the prior question that there was physical injury. And physical injury is and would be very important in this case, but could you please respond to your opposing counsel's point that there was no medical testimony? It's basically, Ms. Smith is with this litany of bad behavior by Mr. Olsen. She's essentially just self-representing, I'm physically injured. There's no medical specialist here or anything, right?
There's no medical specialist. There's not a clinician. That's true, Your Honor. And Ms. Smith did testify about her physical ailments or mental. But we also had Justine Fritz, who testified that Ms. Smith was chronically ill, and we had Robin Ray, who said, "I've seen a physical change in her." That testimony, I think I pointed that out to the court in my brief. And at least for the way I read the case law, that's sufficient. That's some evidence of a physical ailment that's resulting from all this emotional distress that's been levied on her.
And we should take that lay testimony as seriously as a doctor saying, that, she has high blood pressure and she has other medical ailments that I've diagnosed. Is that entitled to equivalent weight when we consider reprehensibility?
Well, the defense could have brought in somebody and said, there's no evidence of it, or trying to refute it. They didn't try and do that.
You bear the burden on this issue. I'm talking about what you guys proved. I understand your point that this case was not tried well, and I agree with you. But putting that aside, what about your side?
And at least the way I read the case law, Your Honor, there's no requirement to have a clinician or a doctor do that. As long as you can show that there's some kind of longstanding physical illness from this, you've met your burden, you've met that element of the negligent infliction of emotional distress claim. So, by the way, on as far as objections to testimony, I would note for the court that Mr. Olsen himself, as a pro se litigant, on the first day of trial, made 6 objections to hearsay. So he clearly knew that the order did not extend to that, the sanction order.
Were any of them sustained?
I'm sorry?
Were any of them sustained?
I believe 2 of them were sustained on other grounds. One was sustained for relevance, one I have that it was sustained on other grounds, and then the other 4 were overruled. So, and there were objections throughout the trial about as to testimony. So again, I think the sanction was clear, and counsel and Mr. Olsen himself knew this. Statute of limitations argument, there was none made at any point. No jury instructions, nothing until after we were through a trial. The only jury instructions were one on equitable apportionment for the expense of maintaining the easement, and there were 1 or 2 others, but they were not on statute of limitations. So.
You mean submitted by counsel for defendant or defendant himself?
Yes,
right? Thank you.
Yes. There's, to me, this case is a case that Mr. Olsen set up by himself, and it was tried the way he wanted it tried. He was pro se the entire time during all these pretrial orders were put in place. He was pro se from July of 2018 all the way through May of 2019, and that's when all the orders were put in place to present a joint pretrial statement, jury instructions, timelines for all the witnesses, et cetera. And he refused to do that. I put in the record, or in my brief, I counted him, I think, 7 times and said, hey, I need this portion of the joint pretrial statement. I need your trial witnesses. Here's my jury instructions. Respond, hey, call me up. Let's talk about jury instructions. And I didn't get anything. I didn't even get a phone call back from him. Later, when Mr. Zarifi stepped back into the case, and we had the order to amend the joint pretrial statement, again, Mr. Zarifi, he made no effort to do anything with the joint pretrial statement. He didn't respond to my emails to him. I think I emailed him twice before it was filed, and he didn't respond. I sent it to him afterwards. He didn't respond. No effort to amend it, no effort to call me up and say, hey, we need to put defense exhibits in, et cetera. So, and I think that's the way that Mr. Olsen wanted to try the case, and I guess to be frank, that's how he tried the rest of the case. So, or whatever led up to that. There is a notion that Mr. Olsen shouldn't be sanctioned for his counsel's conduct. Again, he was pro se during the meat of these issues, and he's chargeable, I think, under the case law with that conduct, and the sanction should not be reduced or viewed otherwise because an attorney later came into the case. The sanction also, did exactly what Mr. Olsen refused to do, and it's not any further. It was the minimum necessary to enforce the court rules and nothing further, and I think it was fully appropriate. I also take issue with some of the arguments made by Mr. Olsen's counsel on appeal, because I don't think they're supported by the record. I would ask the court to be really thorough in scouring the record to make sure things are properly supported. By the way, on the record, you asked about Judge Ostrowski talking about the testimony being either excluded or included by the sanction. If you look at the 3rd day of trial, June 2nd, at page 154, lines 3 and 4, he specifically told Mr. Olsen that objections to testimony were allowed. So, and there was nothing contrary to that told to Mr. Olsen or his counsel at any other point. So, there's an argument about the dog wasn't shot, for example. The testimony was that there were bullet holes in the dog's flesh. So that's a misconstruction of the citation of the record. there's talk also, if the court gets into it, about the preliminary injunction and supposedly, according to Mr. Olsen, no finding by the court that the easement did not conform to the 2001 survey, and Judge Hanna found so in April. It's at ROA 55, he talked about that. He actually made the finding at oral argument, and then Judge Campanolo at ROA 120, page 2, said, I've looked at the record, Judge Hanna did find that the easement, or that the road as constructed by Mr. Olsen at that point did not conform to the 2001 survey, so it was appropriate to find Mr. Olsen didn't comply with the settlement agreement, and it's appropriate to
Counsel,
pursue that.
I'm going to have to cut you off. Your time is up.
Okay, thank you, Your Honor.
Thank you for arguing.
I never do a good job of reserving enough time. There's just never enough time. I'd like to focus on the damages questions. I concur with Judge Stuma on this point that there's an overlap on the emotional distress damages. The plaintiff couldn't say, well, from 3 to 5, I was having emotional distress originating from negligent behavior, as opposed to between 5 and 7 when I suffered emotional distress from intentional behavior. I think this court once said in a case I appealed that the evidence was noticeably thin on damages. It was Desert Palm Surgical Group, and that's kind of the situation we have here with the emotional distress evidence. The punitive damages are outside the constitutionally imposed and case law recognized ratio of 1 to 1, but I'm not even sure this case gets to that level. The jury should have been instructed more conservatively on that point, or should not have been exposed to so much evidence. And we didn't even get to talk about that, all the evidentiary issues here.
Counsel, just to be clear, though, you're not alleging, at least I don't see your brief arguing instructional error.
May have more time.
To answer that question.
Yeah,
I mean, you're arguing maybe the jury could have been instructed additionally had requests been made, but you're not arguing the instructions as given were in error.
Most of them are right out of the books.
Right.
So
I just want to make sure
right.
we're on the same page there.
There's no controversy there, but just in the totality of the evidence that the jury was permitted to see and all of the evidentiary overstepping that occurred, there's really no tenable result here. This just has to be retried under these circumstances.
Counsel, time is up. Thank you both for your arguments. The court will take this under advisement and issue a decision in due course. The court is adjourned. Thanks.